accept your responsibility now that we saw it.
Are there
On a
any
video.
additions or corrections to the
You
report?
didn't accept your
My
responsibility.
concern, I guess I
You
could
said you were
address
with the
this
wrong
after Mr.
person.
Smith said
I'm gonna
the
tell you like I
opportunity
tell
to
everybody
present
else.
evidence
You are the
of
wrong
the
person.
new offense
She was with the wrong
the
person. Y'all were with the wrong,
recommendation
y'all,
that we
you're all, if you're in there
predicated on
doing it, you
the
are
new
the wrong
offense
person.
to be proved up. And that was gonna be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove it up, then.
Okay, let's go through that.
The necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier, kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count one that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County.
Speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count one before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could,
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
they didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and
She
so,
followed the direction. And there's
Yeah.
no Miranda issue since she wasn't
right.
arguably in custody. I don't have any argument. I will go ahead and object if that's an illegal search.
All right, that objection's overruled. I am going to find count one true. And so, let me see, I need to. Counts 2 and 3, she pled true to, so there's a finding of true. Count 2, again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to
Yes, Your
punishment.
Honor. At this stage, now that the state has offered evidence as to the new offense, and the court's found that to be true based on the evidence, I think that the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know if it's the next word.
With the pending charge of this theft, she's not eligible to go to ISF.
If I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony.
It's here,
Oh,
it's
is it here?
mine.
Okay,
Because of the prior
All right.
thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the court.
I mean, go ahead.
The
What-
state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
No, ma'am, I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like I was younger, and like they understand what's going on. And I understand, and like me being away from my kids right now is really hard, cause they been with my mama, and my mama had dementia, and she,
Stop. Stop with everybody else. Because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No, I'm
that
not.
if I send you to prison, that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. Some point, you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation. I
Right.
wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
accept responsibility.
I assume my responsibility.
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm going to tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to,
I'll get the other one worked out today.
okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way.
And just like that, it was over. After multiple chances, repeated warnings, and a new offense while on probation, the judge finally decided enough was enough. Cases like this are a reminder that second chances only work when they're used. Do you agree with the 15-month sentence, or would you have gone another direction?